1st of November 2014. Now, that sentence contains a number of errors. First of all, the 3C leave expiration date has shifted from the 29th of October to the 1st of November. There was, of course, no 3C leave. That is common ground. And again, there is reference to discretion being exercised when it seems as though what the caseworker is looking at is the application of the rules. So there is a confusion as to the exercise of discretion. The caseworker is clearly looking at whether discretion should be exercised, but he or she is misunderstanding what that discretion is. He is equating the discretion with the application of the rules. You did not submit a valid application until 26 February 2015, and therefore your residence is considered broken. Again, the immigration history is not considered properly and fully. As such, you cannot demonstrate that you meet the requirements of paragraph 276b(1)(a). You have also remained in the UK in breach of immigration laws for a period beyond that outlined in paragraph 39e, and as a result cannot demonstrate that you meet the requirements of paragraph 276b(5). That is just wrong. The appellant, when he applied, had lawful leave. He still has lawful leave. That expires at the end of this month, and he has already prepared his application to extend that leave. So that paragraph is just wrong and suggests in my submission a confusion in the mind of the decision maker, who perhaps considers that 39E was applicable to the period after the expiry of the appellant's leave in August 2014. And then the decision concludes with the refusal of the application. My lords, that was then followed up with a pre-action protocol letter from the appellant. This is at page 107 of the bundle. That raises issues in particular with respect to the way in which temporary admission is treated by the decision maker.
Sorry, Pap, what was the date of that?
That was on the same date, on the 13th of June. So he received the decision by email and he responded on the same date. And the response to that is at page 103, and it's just 3 days later on the 16th of June. And the substance of that response is at page 105 of the bundle. It maintains the refusal and says that the refusal decision is correct and lawful and therefore maintained. However, this letter accepts that the period on temporary admission was to be considered as lawful leave for the purposes of paragraph 276b. It still makes the error with respect to section 3c leave, but focuses on the gap between the 9th of August and the 28th of November. There is then a follow-up pre-action protocol letter which begins, it's a lengthy letter, it begins at page 98. It makes a lot of points. It's been drafted by the appellant as a litigant in person. He was drafting this, of course, at a time before Afzal had been decided, and I think he, like many others, struggled to understand exactly how the rule and the policy and discretion work, but he makes the points in my submission that are relevant to his claim. He makes the point about 276b(5) not being properly applied, and he makes the point about the policy guidance not being applied. and that is then responded to on the 23rd of June, at page 96 of the bundle. And the second paragraph of that letter, again in my submission, is confused because it makes reference to what I understand the Secretary of State's position to be at the time, which is that you cannot meet the rules, but it then purports to say that discretion cannot be exercised because you cannot meet the rules. It makes no reference to the policy guidance and no reference to exercising discretion in all of the circumstances. The appellant then filed this claim, and if I could take my lords to page 92 of the bundle, which just sets out the three grounds in the claim form that the appellant was advancing, again as a litigant in person. 1, misinterpreted the law. 2, failed to adhere to the Immigration Act 1971. And 3, failed to use discretion. I won't take your lordship through the grounds, which also make reference to the failure to use discretion and other matters. I would, however, like to take your lordships to page 75 of the bundle, where the Secretary of State sought an extension of time to file her summary defence. And the reason for that was that the Secretary of State was, in the words of the explanation in the application, seeking internal guidance to finalise her position and provide a full response to the tribunal. My lords, the summary defence and lodging of the services at pages 69 to 74. The summary defence maintains that the refusal was correct. There are errors again, I won't go through them. They're set out in counsel's skeleton that was before Judge Gleeson, in terms of the way in which the defence categorises the various periods of leave, still making reference to Section 3C leave. And there is an error in the immigration history as well. But the fundamental point is, in my submission, that the Secretary of State again conflates the application of paragraph 276B and 276B5 in particular with the exercise of discretion. And there's no reference to the policy guidance. My lords, we then have the refusal of permission on the papers. This is at pages 67 to 68. And again, my lords, to add to the confusion that has surrounded this claim, the refusal of permission on the papers by an upper tribunal judge also contains some significant errors in the understanding of the history and the application of the rules. At paragraph 3, the judge states that leave came to an end on the 29th of October when the application that was made on the 2nd of September 2014 was refused. That is not correct. At paragraph 4, in the penultimate sentence, the judge states, paragraph 39 of the E of the rules does not assist the appellant because he was not granted leave following his application of 2nd of September 2014. Paragraph 39E has no relevance to that application because it wasn't in force at the time. And the judge then concludes that paragraph by saying there is no arguable merit to the suggestion in the grounds that the respondent ought to have treated the time the applicant was on temporary admission, release, or immigration bail as lawful continuous residence. That is just wrong. The Secretary of State had conceded that in her first response to the pre-action protocol letter sent by the appellant on the same day as the decision. She also conceded that in the summary grounds. We then have the oral permission hearing and the judgment of Judge Gleeson. That judgment is at page 24 of the bundle. And the appellant's submission is that Judge Gleeson clearly considered that the period of overstaying between the 9th of August 2014 and the 28th of November 2014 was bookended overstaying.
Sorry, just give me those two periods again.
The 9th of August 2014 and the 28th of November 2014.
Thank you.
That period was bookended overstaying within the meaning of paragraph 276b(5) of the rules. That was clearly the submission advanced by the appellant. But Judge Gleeson considered that...
Well, can you just point us to the paragraph you rely upon as establishing the proposition that you've just advanced?
In terms of the period of overstaying that she was considering?
Well, that she considered it to be bookended, to be precise.
Yes, my lord, yes. I think if one goes to paragraph 9 of the judgment, where she concludes that the core factual matrix is not distinguishable from that of the applicant in Upsal. In Upsal, it was a bookended period of overstaying within 276b(5). There is, as Miss Brown has conceded, an 87-day gap in the applicant's residence, which, applying Upsal guidance, cannot count towards continuous lawful residence. The requirements of paragraph 276b are not met, and paragraph 276b(5) does not avail him. All of that reasoning is clearly directed towards a bookended period of overstaying because Upsal would not apply, and there would be no question of a period not counting towards lawful residence if it was not bookended within the meaning of 276b(5). The appellant's application for permission to appeal to the Court of Appeal was on the basis that Judge Gleeson misinterpreted and misapplied Upsal, which was a fairly straightforward submission, that Upsal said that it cannot be counted, but Upsal clearly found that periods before and after can be amalgamated. So the effect of it is that you just ignore the period of bookended overstaying. And what the judge failed to do was consider the difference in the factual circumstances as between Upsal and this appellant's case, and that key difference was that by the time of the decision under challenge, the appellant had already accrued 10 years of continuous lawful residence, even if one did not count the bookended period of overstaying. And the second ground was that the Judge Gleeson failed to apply the Secretary of State's policy guidance, which would in any event have...
Sorry, complete what you're saying, I'm sorry.
Which would in any event have availed the appellant.
I just wanted to be clearer about this because I was unable to detect in Miss Brown's skeleton argument anything about discretion. I read it as dealing solely with the 276B rule governed point.
My Lord, yes, I think the way that the case was put before Judge Gleeson was that this is a bookended period of overstaying, and therefore applying Upsal, he clearly succeeds.
Yes. So then, how does the complaint about a failure to deal with the question about discretion bite? I know permission's been granted,
yes,
but I was puzzled about it because it doesn't really come out of the grounds, and it's not mentioned at all in the skeleton argument. So it's hard to criticise Judge Gleeson for not dealing with it.
No, well, my Lord, I think the way in which I would put it is this, that the case put by the appellant before Judge Gleeson was that this is very straightforward. I have a bookended period of overstaying and you apply Upsal. But if Judge Gleeson was not satisfied that Upsal benefited the appellant, she should have considered the policy guidance, because the policy guidance clearly does benefit him, and when one looks at the actual grounds he has advanced before her, although it was presented in a far more finite manner, because the issues had become far more finite by the time that one gets before Judge Gleeson. When one looks at his claim is clearly relying on the policy guidance and the exercise of discretion. And that was the complaint. Of course, I understand, my Lord, that if that wasn't pressed before Judge Gleeson, it might be that Judge Gleeson's decision was erroneous, but one cannot attach too much criticism to her because this point wasn't pressed.
But it also... Oh, sorry to interrupt. No, you finish and then I'll ask the question.
No, my Lord, I think I was just going to
But myself. I was going to say it goes a bit more than whether the decision's erroneous. It's whether, I mean, public law challenges have always been... Everyone's been told you've got to be disciplined, not do a moving target, and that applies to you and to the Secretary of State, because otherwise it becomes impossible to know. And if it's not advanced before the judge, and there is counsel representing, it does slightly engage what issues are really before us.
My Lord, I understand your concern, your Lordship's concern. All I would say, my Lord, is that when one looks at the claim that was before Judge Gleeson, however it was pressed before her in oral submissions, the claim was clearly that discretion should have been exercised if I don't benefit from an application of the rules. And my Lord will appreciate also that, of course, during the course of the decision-making and the claim being brought before the tribunal, the understanding of the law had been moving because of the decision from the Court of Appeal of Upsal. This is obviously a difficult area. Permission has been granted. And my Lord, all I would say is that it isn't that the appellant is changing his case. He might be changing the emphasis of his submissions, but the case has been the same from the outset.
So where in the grounds do we get Mr. Iyieke's point about discretion? I think it's in paragraph 9 on page 86, but I may be wrong about that.
My Lord, I took my Lords to the judicial review claim form.
Yeah.
And my Lord, yes, at paragraph 9, there is a reference to discretion. Now, again, that reference to discretion is not as precise and forensic as the submission that is now before you, but that perhaps reflects the fact that the decision that was under challenge was also not as precise and as forensic as the way that the Secretary of State is now put. So it has been difficult to identify the errors because those errors have been shifting. The understanding of the law has been shifting over time.
That's probably understating it.
But my Lords, stepping back, I think it's clear that the appellant was saying, look at your policy guidance, exercise discretion, the temporary admission should be counted as lawful residence, and I should qualify for indefinite leave because I made the application within 28 days, etc., etc. And I think that, broadly speaking, is where we are. Although, of course, by the time that we get here, the issues have narrowed down and the focus is much better. My Lord, so we have the grant of permission by the Court of Appeal, but before permission was granted, the Secretary of State advanced submissions, which are at pages 28 to 30 of the bundle. And those submissions were advanced before the court in order to try and persuade the court not to grant permission, that there was no error. Those submissions were advanced by counsel that represented the Secretary of State at the appeal.
Sorry, page?
This is at pages 28 to 30.
Thank you.
And my lords will see that essentially counsel's submission was that Judge Gleeson got it right. And that meant that she got it right that this was a bookended period of overstaying, and she applied Afzal correctly in the provision, the passage in Afzal that the appellant was relying upon was obiter and had no application. So at that point, there was no point taken by the Secretary of State as to the period of overstaying not being bookended and not being within 276b5.
And you're entitled to say that Secretary of State made no objection to the raising of ground 2 on discretion.
My lord, yes.
He dealt with it on merits.
Yes. If I could take my lords to the supplementary bundle filed on behalf of the appellant, just to sort of complete the picture of what was going on in 2014 during this period of overstaying. And if I could take my lords right to the back of the bundle, and that document is the Secretary of State's acknowledgement of the appellant's application of the 2nd of September 2014. And as your lordships will see, it acknowledges that the application raises issues relating to the European Convention on Human Rights, which are complex, and that it falls outside our normal service standards. But having said that, the Secretary of State outdid herself and made a decision very, very quickly on the 29th of October. But my lords will see from that decision at pages 64 and 65 that there is no consideration of the complex ECHR-related issues.
And what were the complex ECHR issues that have been raised?
My lord, we don't unfortunately have a copy of the application, but my understanding is from the subsequent application that it related to the fact that he had a partner who was in the UK and a child. And I think we can get a flavour of that from the pre-action protocol letter that is at pages 62 to 63.
Hang on, 62 to 63.
My lord, yes, it's the next document if
Yeah,
we're
yeah.
working backwards.
25th of November.
Yes, my lord.
Yeah, thank you.
And that was, of course, the only avenue of challenge available to the appellant because there was no right of appeal against the decision to refuse the application. So the only thing he could do is challenge it by way of a judicial review claim.
And there was no challenge to the effect that in your first response you said they're complex ECHR grounds, you should therefore give me a right of appeal.
No, because there was no right of appeal at that time against a refusal of a human rights claim. It was the transitional period. So at that time we only had rights of appeal against certain specified decisions.
Yeah.
So, my lords, at 62 to 63, your lordships will see that the appellant is clearly saying that you haven't considered everything that I've raised in refusing my application.
So, suppose we're with you. Can I just check where we are,
Yeah.
what all this is about?
Yes.
If we're with you, we would quash the decision and it would be remitted anyway.
Yes.
The Secretary of State would have to make a new decision. If we're not with you, we'll just dismiss the appeal.
Yeah.
But you're going to make a new application in any event.
My lords, yes, he's going to make an application to extend his leave.
And rely, no doubt, on the human rights grounds.
My lords, yes.
Yeah.
There is no question that he will be entitled to continue to remain here as long as he makes his application in time because of the nature of the leave that is being granted. He was successful at the FTT. That was based on the best interest and welfare of his child. And he has been granted a further period of leave since then. And so there doesn't seem to be any question of him not being entitled to a further grant.
And just so that you know fairly, the reason for asking you those two questions was whether in those particular circumstances the discretion ground really adds very much, because you're going to go back. You obviously want to say, I qualify for the ILR under para 276B, and the Secretary of State says, no, you don't. And the discretion is going to be reconsidered in any event, because there's, on any view, going to be a fresh decision.
Well, my lord, the fresh application will be an application for extension of leave.
Yeah.
So it doesn't assist the appellant in terms of getting ILR. The benefits to him of getting ILR, of course, mean that he no longer has to make applications. Those applications are expensive.
Yeah.
It means that there is certainty and permanence in terms of his status here. And it also means that he is on the route then to obtaining British nationality. Of course, on the facts of this case, it might well be that the prejudice is limited because one expects that he will get to 2024, and in 2024 he will be eligible for ILR on the Secretary of State's case, which is that this period of leave is not bookended, and therefore the clock starts again on the 28th of November 2014. So 28th of November 2024 he can get ILR. But of course, in other cases, this could be crucial, because it might be that the applicant's ability to get further leave is no longer there. They've exhausted their ability to get further leave, and this period could be crucial to whether they're entitled to ILR and therefore entitled to remain here, or they have to leave the country after a long period of residence. My lords will then see at pages 58 to 61 the documentation that was served upon the appellant on the 28th of November. This granted him temporary admission and also made a decision that he was liable to removal. And at 59, my lords will see a decision to remove the appellant, and there is a right of appeal there, but that right of appeal is only available to him out of country. And my lords, this is a point that is relevant again to the exercise of discretion. We do not know why the Secretary of State did not grant him temporary admission upon refusal of his application of the 2nd of September. One would have expected that he would be granted temporary admission at that point, because at that point it was clearly known to the Secretary of State that he had no leave and was an overstayer. And the grant of temporary admission is a tool available to the Secretary of State to ensure the maintenance of effective immigration control, because by granting temporary admission, one then usually sees restrictions notified to an applicant as to their right to be in the UK, advises them that they should leave, and also generally requires that they report. And therefore it is curious that the temporary admission is granted on the 28th of November and not on the 29th of October, when the decision to refuse his application was made. The appellant doesn't challenge the legality of that decision making, but that would, in my submission, be relevant to any exercise of discretion, because had the Secretary of State done what one would have expected the Secretary of State to do, which is that he grants temporary admission upon his application being refused, of course his lawful leave would have begun retrospectively on the 29th of October. And that might have changed entirely the nature of the overstaying, the period of it, and whether it does come within 276b5 or not on the Secretary of State's own case, and also the size of the gap of overstaying, and whether discretion should or should not be exercised.
Now, this is all very interesting. One of the peculiarities, one of the many peculiarities of this case is that points like this just haven't been dealt with at all at any stage before, have they?
No, and my lord, that is why I
really curious to get to this stage.
Yes, that is why I took my lord through the history of decision making, because that is unfortunately a function of the complete misunderstanding of the legislative framework and the rules themselves and how they apply, and the failure to take account of the detailed immigration history. There has, in effect, in my submission, been an attempt to exercise discretion by the Secretary of State in this case, but that attempt has failed completely because the attempt was basically synonymous with an application of the rules. And that is why I make all of these points. These are matters that could have and should have, in my submission, been considered.
So we've really shifted quite a long way off the question of whether 276B applies on the facts. I'm not saying you've abandoned it, but we're now... No. The focus has shifted or expanded very much to encompass discretion.
Yes, and my lord, that might be a function of the way in which I have chosen to present the appeal, which might not be the best way to present it. I'll let your lordships be the judge of that. But I'm trying to get the factual scenario set, and I will then come back to the legal arguments.
Yes. And just on the factual scenario, can you help me with the documents to which you just took us, supplemental bundle, pages 58 and following? Because I'm struggling to find within this document the bit that grants temporary admission. I see all the stuff about notice of removal and so on. Where is the bit that grants temporary admission?
My lord is right, we don't actually have that document. My lord, these are the documents that the appellant has access to.
Right, so there would have been another document of the same date.
It would have been another document, my lord, yes.
Right.
But the fact that he was granted temporary admission, of course, is not in dispute. I think it might be that the appellant has a document.
Dated.
Should be dated the 28th of November.
Yes, my lord. It's the it's dated the 28th of November 2014.
No doubt you'll be able to get us a copy over.
I can, my lord. It contains reporting requirements as well, and I will arrange for that to be emailed.
And make sure that Mr. Keith obviously has a copy.
Thank you. All right, where do you want to go to next?
My lords, then you have the at page 55 the response to the pre-action protocol letter of the 18th of December. And my lords will see from paragraph 6 of that letter that in this, what I would call supplementary decision, although it's a response to a pre-action protocol letter, you actually have consideration of the issues raised by the appellant in terms of Article 8, the application of 276 AD1 of the immigration rules, and the application of Section 55 of the 2009 Act, the duty to safeguard and promote the welfare of the appellant's child. So those are things that one can see are absent from the decision of the 29th of October.
So is this now the new decision?
It's just, my lord, the sequence of events during this period, and the reason I point to this sequence of events is because, again, I submit that this would all be relevant if the Secretary of State had properly looked beyond the rules to see whether this period of overstaying should actually be overlooked. If it was necessary to do that, of course, the appellant's primary submission is that this is bookended overstaying.
Yep.
My Lords will then see at page 54, on the 23rd of December, that the appellant was asked to attend an interview to confirm his nationality and identity, and it appears it's a letter from the local immigration team at West Midlands. It appears that this was in preparation of enforcement action pursuant to the notices served on him on the 28th of November.
Well, this is the sort of letter you get before you turn up and then you're arrested and put into immigration.
Or it might be that he was just being processed for a removal.
Yeah. With bail in the interim,
Yes. And my Lords will then see on pages 52 to 53 the covering letter that accompanied the application on the 28th of February 2015, which was ultimately successful. My Lords, when one looks overall at the sequence of events during this period, it is clear that the appellant made a mistake initially in not applying before the expiry of his leave. But he corrected that very quickly, and within the 28-day period that was provided for in the immigration rules at that time. Thereafter, there has been no complaint about his conduct. He has not failed to comply with any requirement placed upon him by the Secretary of State. And it is clear that the application that he ultimately made, which was based on, one can see from the 28th of February 2015 application, it was based on human rights grounds, and in particular the family life element with his child and his wife. That was ultimately successful in 2017. I don't doubt that by the time of the decision in 2017, the circumstances would have evolved, but the point is that that application ultimately resulted in the grant of leave, and his conduct during this period cannot really be criticised, except for the delay in making the initial application. But even then, he was within the grace period afforded by the immigration rules.
So this letter of the 28th of February 2015 raises all the discretionary factors on which your client would like to rely, and he's then got leave outside the 276B. So what is the continuing complaint in this appeal about the failure to exercise discretion?
My Lord, no. The failure to exercise discretion in this appeal relates to whether he is entitled to indefinite leave to remain on the basis of 10 years long residence. The February 2015 application and ultimately its success relates to whether he's entitled to remain in the UK. It's only if he's successful in being entitled to remain in the UK that he can even contemplate the grant of indefinite leave. So the discretion that was exercised there, and that was discretion obviously within the parameters of Article 8, is different to the discretion that I'm referring to in the context of an ILR application on long residence grounds. Here, the discretion is simply about the period of overstaying. Should the Secretary of State, of course, has power to go beyond the immigration rules. The immigration rules are simply the rules she applies. She has wide discretion, as I'll come on to from the Supreme Court's decision in Munir. She has wide discretion to grant applications even where applicants cannot meet the requirements of the rules and cannot meet the requirements of any guidance. She can grant applications. And the appellant's position is that you didn't consider whether my circumstances merited the grant of ILR because that period of overstaying, even if it doesn't come within your rules, is such that discretion should be exercised. And I will take you, my lords, to the policy guidance, which sets out some parameters within which discretion would normally be exercised. And there is, and I've referred to it in my skeleton, a section on out-of-time appeals which contains a chronology that is very similar to the sort of chronology we have here. And in those circumstances, the guidance is that, you know, you may grant
is this a convenient moment at which to look at that guidance?
My Lord, yes, we can absolutely go to that guidance now. It is in the bundle of authorities. Page begins at page 140. If I could take my lords first of all to page 145.
Sorry, just before we go from page 140, I see this is published on 11th of May 2021, and experience in these cases show there's a great danger of anachronism. What was the applicable guidance at the relevant time, or was
it was this one, my lord, because the decision is the 13th of June 2021.
Right.
Under challenge, so it would have been this guidance. It is, yes, it is also the current guidance, my lord.
Sorry, I thought you were making points about the Secretary of State's historic failure to exercise his discretions back in 2014 and 2015.
My lord, no. I think I've perhaps not presented this as clearly as I should. My point was that any discretion that needs to be exercised now relates to that period of time.
Yeah, so what you're saying is, as I understand it, is that in taking the decision complained of on the 13th of June 2021, the Secretary of State failed to exercise her discretion, and what she should have done was to consider exercising her discretion, taking into account the factors that the appellant had historically raised back in the 2014 to 2015 period.
My lord, yes, and it's not taking account of the factors raised there. It's just taking account of the sequence of events.
Yeah.
All right.
Because the discretion relates to the overstaying.
Yeah.
So the nature.
But I think the word you used earlier was to overlook. This argument assumes, contrary to your other submission, that you don't get within the rules.
My lord, yes.
The reason being there's a small period, whatever precisely it is, of 87 days or whatever, during which there was no application that resulted in leave, and he was out of time. Your submission is that the Secretary of State failed to exercise her discretion to consider whether that period should be overlooked.
My lord, yes. And of course it might be that the Secretary of State would have exercised discretion and said, I'm not going to overlook it. In those circumstances, the challenge would be very different. But the challenge at the moment is that you simply haven't exercised the discretion.
Yeah. So can I just reformulate that, which I hope is to assist this. It's not failing to exercise the discretion to overlook it. It's a failure to exercise the discretion to take it, to count it as a continuous lawful residence. Is that right?
My lord, I guess it could be either, because by the time of the decision, even if one overlooked it, in that one treated it in the way that Upsall would have treated bookended overstaying, he still would have benefited from ILR because he'd accrued enough leave by that time, if that makes sense.
Yeah, it does. Thank you very much. Sorry to interrupt.
If I could take my lords then to 145, and I've listed in the skeleton the areas of the policy guidance that have provision for discretion. I won't take my lords through to all of them. But one can see here, because temporary admission is relevant to this appeal, there is a short section under the subheading Applicants in the UK with Temporary Admission. And in my submission, this is a significant discretion beyond the requirements of the rules, because what the policy says is that you can grant leave outside the rules so that somebody can apply and benefit from ILR.
6 months Code 1 outside the immigration rules means...
It's just outside the rules. It's just, I don't know what Code 1 is, my lord, but it's 6 months outside the rules.
Yeah, I can read that bit. It was just what Code 1 meant.
I don't know what Code 1 is, my lord. It might be that my learned friend can assist, but I doubt it.
Not probably on his feet, but you can make inquiries, yeah. Thank you.
But my lord, it's a confusing discretion.
Yeah.
Because if one reads the sentence, it says discretion can be exercised outside the rules if an applicant with temporary admission meets all the other requirements of Rule 276B. Now, it's not clear what all the other requirements are and what requirement the applicant cannot meet.
So which page are we on?
145.
145, I thought it was, okay.
My submission is that the only sensible way to read this is that the applicant doesn't have the 10 years lawful residence, and the grant of leave outside the rules converts the temporary admission to lawful residence and therefore enables him to meet the rule.
That would be an understandable potential construction. On the other hand, if you don't have the 10 years lawful residence, you don't meet all the requirements of Rule 276B.
And that's why, my lord, it's curious that it says meets all the other requirements. So there's clearly one requirement that's not met, and it's not clear which requirement that is.
Well, it must be, I suppose, the time one.
That's the way I would read it, my lord. But in any event, it's clearly an exercise of discretion beyond the rules, and it's a significant exercise of discretion because it is not just overlooking something, it's positively doing something that enables a person to then apply and be granted ILR. My lords, we then have, I think, which is relevant to this case, the section breaks in lawful residence. And this begins at page 155. The subheading that is relevant is time spent outside the UK. That's clearly an error. But the subheading under that is correct, gaps in lawful residence. And the guidance says you may grant the application if an applicant has short gaps in lawful residence through making previous applications out of time by no more than 28 calendar days, where those gaps end before 24th November 2016, has short gaps in lawful residence on or after 24th November 2016, but leave was granted in accordance with paragraph 39E of the immigration rules. There is reference to short gaps in both of those bullet points, but there's nothing that suggests that that provision, which is reflected in 276b(5) of the rules, is restricted to short gaps. Those gaps can actually be quite long, because if an application is submitted within 28 days or within 14 days, it's likely that it will take some time for the application to be decided. And if that application is refused, but subsequently granted on appeal, then that gap can be even longer. And one can see the sort of time frame that you can get in this appeal itself, where the application is made in 2015, February 2015, and he is eventually granted leave in August 2017. So the short gaps, I think, is, I'm not sure why that description is there, but it doesn't reflect the reality of the way in which this discretion or this application of the rule would work.
So can I just ask, you contend that he made the previous applications out of time by no more than 28 calendar days?
The 2nd of September one, my lord, yes.
Right. And those gaps ended before the 24th November 2016?
My lord, that again is something that is not reflected in the rules, and I cannot explain why that is there in the guidance. I don't think that in practical terms that is the way the Secretary of State applies the rules or the guidance, because it would be inconsistent with the text of the rule. But there is no requirement that the gap
did your gap end before the 24th November 2016?
It did.
It did.
Because it ended on the 28th of November 2014, in light of the temporary admission being considered as lawful residence.
And can you just, for my note, show me the bit where you, which is common ground that temporary admission is lawful residence?
Yes, my lord. I'll come to that.
Yeah. Don't let me take you out of order, but just so I've got that.
My lord, that is at page 160. And that is an application of the rules. It isn't an exercise of discretion.
No.
And my lord will see from example 1 how generous that provision is. It effectively turns 8 years of residence in the UK by a person that seems to have arrived without leave, certainly with no proper claim to be in the UK, might have arrived with a visa, but then that visa was cancelled, is granted temporary admission at port on the 31st of January 1995, remains on temporary admission until the 27th of June 2003, over 8 years later, is then granted 4 years leave, likely because of circumstances that have developed whilst that person has been in the UK for 8 years without any proper basis for being here, and is then, within 2 years, entitled to the grant of ILR because of the way in which temporary admission is treated. And that is important in my submission, because the appellant submits that that is consistent, that treatment of temporary admission is consistent with the way in which the appellant says 276b5 should be construed in the supplementary skeleton. So whereas the Secretary of State says that an application made within 28 days that is not successful cannot avail an applicant of the disregard provisions in 276b5, the appellant says that is not correct. 276b5 simply requires an application within 28 days. It doesn't require that application to be successful, but if leave is subsequently granted, then the entire period is disregarded. And it might, on the face of it, seem a very generous provision, but when one looks at the way that the temporary admission provisions work, and the way in which the other provisions also work, and I'll take my lords to the Refusal judgment, which also had a curious immigration chronology after the application that was made towards the end of the first period of leave, which covers the bookended period there. That is the way that the rule works, and that is the way that the policy overall works, and one can see that very clearly and very starkly from the example given in the policy guidance, where 8 years on temporary admission is turned into lawful residence for no other reason than that leave was granted at the end of that period. There is no reason why the appellant's position should be any different, in that he made his application within 28 days, so he meets the threshold for getting into 276b5, he makes the application within 28 days, and he is then eventually granted leave. There is no reason why he should not be treated in the same way as a person, such as the one in this example here, who has temporary admission and then is granted leave. And another way of looking at it is, why should the fact that he was granted temporary admission on the 28th of November be treated so favourably, and his positive action in making an application within 28 days, and on the facts of this case, following it up diligently, why should that not also benefit from the same treatment, which is that that period is not detrimental to his application for ILR.
Can I just ask a question about page 155, or are you going back to that anyway?
My Lord, I wasn't going to go back to it, my Lord, but
I just wanted to understand. Just wanted to understand the
Yes.
submission, because the top of the page tells the reader that we're being told about circumstances that break lawful residence for long residence applications, and when you can use discretion. Clearly, the wording under the heading "periods of overstaying" is dealing with discretion. Is it your submission that the section under the wrong heading "time spent outside the UK" is also about discretion?
My Lord, no. My submission is that the policy guidance is not drafted in the best way, which is not surprising given that it is in relation to 276B.
Yeah.
But my Lord, that initial section that says that this page tells you about circumstances that break lawful residence and when you can use discretion is clearly incorrect, because this section is not just about the use of discretion, it's about the application of the rule and circumstances where you may go beyond that and exercise discretion. And that's clear when one looks at the subheading periods of overstaying towards the bottom of 155.
Mm-hmm.
That whole section talks about the exercise of discretion.
Yeah.
And if one then goes over the page, after the bullet points, you can see any decision to exercise discretion and not refuse the application on these grounds must be authorised. And then it also says when granting leave in these circumstances, the applicant must be granted leave outside the rules for the same duration and conditions that would have applied had they been granted leave under the rules. And one can also see, my Lord, that when one looks at the examples, you can see the difference in treatment between circumstances that fall within the rules and circumstances that fall outside the rules. So, for example, example 1, it says grant the application as the rules allow for a period of overstaying of 28 days or less when that period ends before 24th of November 2016. But then if one looks at example 3, that refers to the exercise of discretion because one is going beyond the rules.
Yes. Well, I had initially read the section headed "Gaps in Lawful Residence" as an attempt to summarise the effect of 276B, rather than addressing any question of discretion.
My Lord, that is the way that I read it as well, my Lord. And then, my Lord, finally, if I could take, in relation to this policy guidance, if I could take, my Lords, to page 162. And this is the section on out-of-time appeals. My Lords, perhaps if I could ask your Lordships to just quickly read that section rather than me reading it out to you. My Lords will see that this is clearly discretion outside the rules, and if I could just take your Lords in particular to the last section where the passage begins, you should normally use discretion to disregard the break in continuous lawful residence, and then a series of scenarios. and the scenario that is, in my submission, comparable to the circumstances of the appellant is that the out-of-time appeal was subsequently dismissed, but further leave was granted following a further application made, and then within 28 days, or in accordance with paragraph 39E. And when one looks at the sequence of events in the appellant's history, there is, in a sense, an out-of-time application, but that's within 28 days. That is refused on the 29th of October, but received by him on the 1st of November. And then within 28 days of that, he benefits from leave again in the context of 276B, because that is when he's granted temporary admission. And so the gaps we're looking at are comparable to the gaps in this scenario. Of course, I'm not saying that this directly applies to the appellant's circumstances, but it gives you the sort of area where the Secretary of State would be prepared to exercise discretion. And of course, that assists the appellant in saying, well, my circumstances are not, of course, on all fours with this situation, but they are the sort of circumstances where the Secretary of State can consider exercising discretion and should consider exercising discretion. And of course, this is policy guidance, not the rules. So the Secretary of State is not in a straitjacket in that these are the only circumstances within which she can exercise her discretion. And just to underline that, because we have just looked at the policy guidance, if I could take my lords to the case of Munir, the Supreme Court, which begins at page 6 of the authorities bundle. I've quoted the relevant extract from it in my skeleton. Paragraph 2 of the judgment sets out the central question that arose in those appeals. And it was all about the nature of policy and concessions. And the key part of the judgment for the purposes of the appellant's submissions begins at paragraph 41, which is page 19 of the bundle.
Sorry, paragraph 41.
41, my lord. Yes.
Thank you.
And my lords, then 44 and 45 and 46.
Or is this all about whether these policies needed to be laid before Parliament? Yeah.
My lord, yes.
Yeah.
And the point is that by definition, because this is a policy, it's not a rule. And by definition, that means that there must be flexibility. And therefore, one cannot simply read the policy and say you don't come within it and therefore you don't benefit from discretion. The policy identifies areas within which discretion would be expected to be exercised, but each case must be considered on its merits, and the policy must be flexible. My lord, that I think completes my submissions on the last part of the appellant's case, which is the response to the appellant, the respondent's notice, so to speak. If I could take my lords to the replacement skeleton in the supplementary bundle actually, my lords, it might be more useful for me to complete the submissions in response to the Secretary of State's position. So if I could take my lords to the appellant supplementary skeleton, which is the first document in the supplementary.
The 12th of July one.
My lord, yes.
Yeah.
I've set out the background, which is the start of the skeleton. I've dealt with the points from paragraphs 25 onwards. My lords will see at paragraph 30 the list of factors that I say would be relevant to an exercise of discretion, which the appellant says has simply not taken place on the facts of this case. I just wanted to now focus on paragraphs 19 to 24, which is the submission that the Secretary of State is wrong in asserting that the appellant cannot benefit from the disregard provisions in 276b5 because the application that was made within 28 days was in fact refused.
Hmm.
276b5.
So this is. Can I just check? These submissions are directed to showing that you come within para 276b.
My lord, yes.
Yeah. Thank you.
276b, my lord, is at page 4 of the authorities bundle. I've also set out 276b5 in my skeleton, so it might be that my lords don't need to refer to the authorities bundle. Reading the provision on its face, the requirement is simply that the previous application was made before the 24th of November 2016 and within 28 days of the expiry of leave. There is no requirement that that application should have resulted in the grant of leave. And as I say at paragraph 21, the Secretary of State's position requires additional words to be read into the rule.
Well, wouldn't it say a previous application rather than the previous application, if that was right?
My lord,
as long as you made an application, then you're fine.
I accept that it is curious that it uses the application,
Yeah.
but I'll come to, if I could take my lords to paragraph 39E, which is
Well,
that...
before we get into that, one thing I'm a little bit puzzled about is how you say you come within this, even if you're right on the construction. Because the relevant application here is the February application, is it not? And that was not made within 28 days of expiry on any view.
My lord, that is if one reads into the rule, I would say reads into the rule, a requirement that the application is the one that was successful. So if the requirement was that you make an application within 28 days and that application is successful, then the period of overstaying will be disregarded. Then my lord is absolutely right, because the first application didn't succeed. But if the requirement is simply that you make the application, or an application, and I recognise that that is a difficulty for the appellant, and there is a difficulty for the respondent because it requires words to be read in, and one therefore has to look at this in the overall context of the rule and the policy, because the rule is not drafted very well. It's, in my submission, drafted without...
Well, I think there are enough authorities showing that it's very badly drafted, and
yes.
It leads to a lot of litigation which shouldn't be taking place.
Yes.
Can I just ask you this question before you get into the merits of your points? How does the submission you're making at the moment chime with what Sir Patrick Elias said in Afsal? Because lots of people can read this rule in different ways, so that's one of its spices.
Yes.
But we are where we are. But it might, and just for you to deal with, be thought that what Sir Patrick and I have said in AFSAL on the effect of 2765 B5 binds us.
My Lord, yes. The appellant's position is, in relation to what was said by the court in AFSAL, that even if that is correct, as long as the appellant falls within 276b5, he still succeeds, because when one takes away that period of overstaying, one can still get 10 years lawful residence. If one counts the period prior to the 9th of August 2014 and the period after the 28th of November 2014, he accrued 10 years just before the decision in June 2021.
Yes, but I'm still struggling with the basic factual premise of your argument, and forgive me if I'm being obtuse. So, your client makes an application on the 2nd of September 2014, and that's refused on the 29th of October 2014. No leave to appeal, as you've explained. Now, I can understand there's a dispute about the effect of that, because Secretary of State says, well, that could be disregarded under 27b5a if leave was granted, and you dispute the if leave was granted point. That I understand. That's perfectly clear. But suppose you're right about that. Suppose there is no requirement that leave be granted. I still don't understand how that helps you, because you still have then the period following that. Because even if one takes into account temporary admission from the 28th of November 2014, and that counts as lawful because leave was subsequently granted pursuant to the February 2015 application, you're still stuck with the period from the 30th of October to the 28th of November 2014, because there was no application at that period.
My Lord, if it's the entire period between periods of leave that is disregarded. So it's not that you only disregard the period between the application and the decision. If the appellant's construction is right, if I could just take my Lord's 276b5, and it's the second part of 276b5 that is relevant, any previous period of overstaying between periods of leave will also be disregarded where the previous application was made before 24th November 2016 and within 28 days of the expiry of leave. So what we say is that if you take
regardless of the outcome of that application.
That's right. So if you just take that at its face value, there is an application made within 28 days before the 24th of November 2016. There is a period of leave prior, and there is a period of leave subsequently, and therefore the entire period between periods of leave is disregarded. It's
a curious interpretation. I mean, it's a curious intention to ascribe to the Secretary of State, because there could be, in an extreme case, an extremely long gap, at the end of which you have a situation such as you were instancing with the grant of temporary admission maturing into leave for no very good reason.
My Lord, yes.
And just because there was a hopeless application made at some point within 28 days, all of that would be disregarded.
Which is why, my Lord, I emphasise the situation for those on temporary admission and the example in the long residence policy guidance, which, on the face of it, is a person that entered the UK with a hopeless entitlement to be here, was here for 8 years without any entitlement except for temporary admission, was granted leave thereafter, I would say most likely because of events that took place whilst he was here without any right to be here apart from the temporary admission. But the effect of the rule is that that whole period is considered lawful leave. And this construction is consistent with that policy. And that's why I say that it is curious, but it is consistent with the way that the rule has operated for years.
Okay, so coming back to the question that my Lord Justice Warby asked you, can you assist us as to what in your submission is the antecedent to the words the previous application? What is that referring to, given that it says the previous application and not a? What's the antecedent?
It's just the application that was made within 28 days. And this is where, and this is why I wanted to take my laws to 39E as well, because if one looks at A and B in 276B5, there is, curiously, a different description, a different adjective used for the application based on whether it's 39E or prior to the 24th of November 2016. So in A you have the previous application, in B you have the further application. And that is again something that is difficult to understand. And I think that in trying to understand it, if I could take my laws to 39E, I think what might have happened is that in drafting the provision, the drafter considered that 39E would only apply if there was a previous application and then a further application. So if one looks at 39E, 39E2 looks at the situation where there has been an application that has been refused and then there is a further application within 14 days. And that is consistent with the language used in 276B5B, the further application, because it would be a further application if it was within 39E2. But what it fails to take account of is that 39E1 also makes provision for applications such as that made by this appellant on the 2nd of September 2014, which is that leave has come to an end. He didn't make an application prior to leave expiring, but made it within 14 days, and there was a good reason beyond the control of the applicant. So 39E represents a tightening of the discretion, because you can't just make an application within 14 days of becoming an overstayer. There has to be good reason as well, whereas previously you could just make an application within 28 days and that was considered acceptable under the rules. But the rule has been drafted, it would appear, with only 39E2 in mind, and not considering that 39E1 is going to be a previous application, not a further application. And 39E uses the terminology of the application. And because the amendment to 276B5 came into force at the same time that 39E came into force, my submission is that that might well explain why the language of the application is used, borrowing from 39E as opposed to an application. And I fall back on what my Lord said in Hock, that it might well be that there was not much thought given to the way in which all of these parts were going to work with each other. And that is why one has curious language. But if one steps back from the detail of the language used, my submission is that the appellant's construction is consistent with the overall language. There's no requirement that the application should be successful, and it is also consistent with the overall policy of 276B, because it is entirely consistent with the way that temporary admission is treated. And there is no reason why a positive action on the part of an applicant in making an application within the grace period should not attract similar protection to what might well be the accident of the Secretary of State granting temporary admission at some point in time. And my Lord, that doesn't leave this open to abuse. On the facts of this case, it's clear that there is no abuse. The applicant, the appellant, was in touch with the Secretary of State, complying with everything that he was asked to do. He was following his application up. and very soon had an application pending and was granted leave. But if there is abusive use of this provision, then 276B itself contains the mechanism by which the Secretary of State can step in and say that, notwithstanding the fact that you meet the requirements of 276B1A and 276B5, I'm going to refuse your application, because she can refuse on general grounds, and she can also refuse under 276B2, which is that having regard to the public interest, there are reasons why it would be undesirable for a person to be granted indefinite leave. And so if there has been that sort of abusive behaviour, then an application can be refused. And I guess that that would probably apply to somebody on temporary admission as well, who decided to abuse the temporary admission. Because there is nothing in the rule that imposes any requirement that an applicant should have conducted him or herself in a certain way after the grant of temporary admission. So it might be that a person, after being granted temporary admission, behaves in a way that ensures that that temporary admission continues for a long time. Not by making legitimate applications and legitimate action, by illegitimate.
Can you help me on this? I'm still struggling to understand the logic of this. I can understand the logic of a submission that says, well, you should disregard overstaying between periods of leave where those periods are covered by an extant application, even if the extant application is ultimately successful. I can understand your submissions in support of that interpretation. But what's the logic of saying that you should disregard overstaying when there is not even an extant application?
My Lord, I'm not saying that. What I would say, my Lord, is that the logic is that you're treating an applicant in the same way that the rule treats somebody on temporary admission. But
there's a clear difference there, because while you have temporary admission, you're lawfully in the country, provided you subsequently get leave. You've shown us that that's very clear. So how is that analogous to someone who has no extant application for a period of time?
Well, my Lord, when somebody has temporary admission, they are not lawfully in the country during the period of temporary admission.
But it's capable of backdating.
It's capable of backdating if
But it's
you're
not capable of backdating if you've got no application.
Well, my Lord, there must be something that results in the grant of leave. So there will be an ultimate application or a positive step by the Secretary of State. And what I'm saying is that when one looks broadly at the way...
Of course you've got a subsequent successful application. That's why you're concerned about overstaying between periods of leave. That's why the question arises.
Yes. And so one looks at the behaviour at the outset of that period and the fact that leave has been granted, and that's exactly what happens with temporary admission. One is looking at the fact of temporary admission at the outset of the period and the fact that leave is subsequently granted. One is not looking to see what happened in between. That's clear from the example. And my submission is that when one looks at it in that way, the two situations are analogous. It might not be entirely on all fours, but it's also not wildly different. And again, it's the behaviour at the very outset of the period of overstaying that is the trigger to that period being disregarded. If you don't behave in that way at the outset, then you don't get the benefit of the disregard provision. It might be that it doesn't make much sense, my Lord. I say that it is consistent with the temporary admission policy, but of course we're looking at the rule in the context of the construction in Hock, which said that the rule has been drafted so that there are provisions where there should not be. One has to break the rule up to make any sense of it. And so one is not looking at a rule that has been very carefully thought out, but one has to give effect to the rule. And in my submission, the rule is what it says. And again, I reiterate that even if one takes it at face value, that's not entirely inconsistent with the overall policy, as reflected in the way that temporary admission has been treated for some time. It is also part and parcel of the flagship policy of the rules in terms of how the Secretary of State treats overstaying. There has, over a period of time, been a tightening of the circumstances in which overstayers can succeed within the rules. And that is now reflected in 39E. And so it's not, in my submission, inconsistent with the overall policy of the rules for the Secretary of State to reward somebody that makes an application within a certain period of time as compared to somebody that doesn't. And in my submission, that also makes sense, because once somebody makes an application within a short period of becoming an overstayer, that person is also enabling the Secretary of State to exercise immigration control properly, because there is an application, there is contact with the applicant can be granted temporary admission, the applicant can be monitored. But if somebody doesn't make an application, that person disappears. And I think that that is the underlying policy rationale behind the tightening of overstaying exceptions, and the way in which that is implemented in 276b5 is consistent with that broad policy objective, as well as the way in which temporary admission has been treated for many, many years. And it is, in my submission, the way that the rule reads, unless one puts words into the rule that requires the application to be the successful application. My Lord, I don't think there's anything much more that I can say in relation to that. That is the appellant's submission. I recognise that it is not entirely straightforward. It's not a straightforward path, the appellant's construction, and at the same time the respondent's construction is also not a straightforward path, and one has to find the meaning from the rule somewhere from between all of that. The appellant's submission is that when one looks at the overall policy of the rules, the overall policy of 276b, that the appellant's construction makes sense and is consistent and faithful to the language of the rule.
Was this submission advanced in Hoc or Absal or even Akinola?
My Lord, it simply didn't arise on the facts in those cases.
Yeah.
So it's not something that has been previously considered. My Lord, that completes my submissions in response to the Secretary of State's position as reflected in the 6th of July skeleton argument. In terms of the appellant's position with respect to the overstaying being bookended, I think I'm correct in saying that if my Lords find that the overstaying was bookended, the Secretary of State will not be submitting that Afzal was correctly applied by Judge Gleeson. And I don't want to therefore spend too much time on that. But I would just refer you to the submissions made in my skeleton argument at pages, in the supplementary bundle, at pages 23 to 31. The reason I refer to the whole section is that it also includes the application of the policy guidance, and it also makes reference to the language used in another rule that has not yet been considered in Hoc or Afzal or any of the other long residence cases. And if I could just take my Lords to that rule, it's at page 5 of the authorities bundle. And it's 276 ADE 1, 3, 4, 5 and 6 that contain the word that is relevant to the appellant's submission, and the word is discounting. And the appellant's submission is that the way in which discounting is used in 276 ADE1 is clearly the way in which the Court of Appeal in Afzal construed disregard. And following on from the reasoning in Afzal that one cannot have disregard meaning two different things in 276b5, the appellant's submission is that one also cannot have disregard meaning discount in the same set of rules. There must be some coherence to the overall immigration rules and the language that's used. This is something that's not been looked at in previous cases, as I say, and in my submission it might well be that if my lords are looking at the impact of a bookended period of overstaying in this case, that Afzal needs to be reconsidered, and that in fact disregard means what the Court of Appeal in Hock said it means, and what we say the Secretary conceded it meant in Hock, which is that that period is counted rather than discounted. And if I could take my lords also, and I've set this out in the skeleton as well.
And sorry, just so I understand the submission, that is because here it says discount rather than disregard.
That's right, and it's then the way that discount is to be applied. So, my lord, if I could, if we go to page 65 of the guidance, which is at page 249 of the authorities bundle. And it's the section, again, continuous residence. And then the paragraph towards the bottom of the page, you should be aware a period of time spent in prison will not break the continuous residence of an applicant applying on the basis of their private life in the UK. Rather, time spent in prison will not be counted towards the period of residence, but time before and after that imprisonment can be aggregated to make up the full amount of time. Now that, in my submission, encapsulates the way in which disregard was construed by the Court of Appeal in Afzal.
I can see that, but you then have to make the further submission that although Afzal was on this point, and it was certainly not obiter, as it was in Hock on this point, we can say it's per incuriam?
Yes. That's the submission I've made in the skeleton, because it's a relevant provision of the rules that wasn't considered, and it clearly sheds light on what disregard is to mean. Because had the Court of Appeal in Afzal seen that the interpretation it was giving to disregard was actually what discontinue means in the rules, it might well have...
Discount, you mean?
Discount, sorry, yes.
Yeah,
discount.
no, I understand, yeah.
It might well have reached an entirely different conclusion, because that would have changed entirely the reasoning. The reasoning of Sir Patrick Elias was that one cannot have disregard meaning two different things in the same provision. But that reasoning must apply also to having two different words meaning the same thing in a set of rules.
That is a different point. It's a related point. It's not
a related point, my lord, and it's...
But if we were to consider this point properly, we'd have to consider whether either of those words or any other words are used to mean the same thing in the same set of rules. Are we? Because we would then be at risk of making a per incuriam decision ourselves if we focused entirely on these two rules.
Yes.
With these two words.
My lord, the thing about these two rules and these two words and these two rules, that they are directed towards the same issue, the continuity of residence and breaks in lawful residence. And therefore, the use of discontinue as opposed to disregard here, and the use of disregard there as opposed to discontinue, is significant. And you also have, of course, the policy guidance. You have the concession by the Secretary of State in Hock. And when one puts all of that together, in my submission, it is clear that in fact, the Court of Appeal in Hock, when one takes this into account, was correct in the way that disregard ought to be read in 276b5.
Is this the relevant version of the family policy? Because this is dated 7th December 21.
My Lord, this is the policy that was in place until very recently, because the rules have now changed. So 276 ADE is gone from the rules, and there is now an appendix. So
does it use discount?
No, the appendix now uses entirely. It's a different structure and different terminology.
Because normally when one looks at this, normally this point about not using the same word to mean different things or different words to mean the same thing arises in the context of a single piece of legislation that is made where the elements you're looking at are enacted contemporaneously. It obviously does also apply to amending provisions. This is not legislation, it's a particular, rather peculiar set of rules.
Yes.
Which, as everyone knows, change, as you've just illustrated,
all the time.
Almost daily. And don't have a single author. No one will pretend that they do.
Yes.
In a context where, as my Lord has said eloquently and crisply, they're a bit of a muddle. So it may be that rule has to yield to the reality that the authors, whoever they may be, of these various rules are not the same and not thinking particularly coherently.
My Lord, it might well be. That is a matter for your lordships, of course, but my submission is that when one looks at this, it does, in my submission, suggest that the Court of Appeal in Upsal might have misconstrued disregard. And of course, then one has to look at the policy guidance, because the appellant's second ground of appeal is that if you apply the policy guidance, he benefits from that period of overstaying as being counted towards his 10 years lawful residence, and that is consistent with the concession in Hock and the Secretary of State's practice. That is the second round. I don't think I need to take my lords through it in detail, because I don't think that there is much dispute about the application of the policy guidance, but I'll be corrected and I can come back on that.
This is your ground that if you apply the policy guidance properly, regardless of what the rule says, you should have been granted leave.
If it's bookended overstaying.
Right. Can I just finish off your point about Afsal being per incuriam? What happened to Afsal? Was there an application for permission to appeal?
My Lord, it's still pending.
It is still pending, and no doubt on the basis that Hock, albeit obiter, had come to a different conclusion.
Yes, that is one of the bases, and that it's wrong. But there were also Section 3C issues in Afsal that have also been also the subject of the application for permission.
And when was the application made? Sorry to ask you all these questions.
December last year, I'm told, my Lord.
And no decision as yet?
No decision as yet, my Lord.
Thank you. Sorry to interrupt.
My Lord, I just wanted to summarise again the appellant's position, because it's a little bit confusing, and I've almost made the submissions back to front. The appellant's submission is that on the basis of Judge Gleeson's finding that the overstaying in 2014 was bookended, he benefits from the judgment in Upsal, regardless of whether the disregarded period is counted or not, because he had enough days either side of the period of overstaying to get him to the 10-year mark by the date of the decision. That is all he needs if the overstaying is bookended. But in addition to that, he has filed a ground that says that if he is wrong on that, the policy guidance in any event avails him, and in accordance with the policy guidance, that bookended overstaying would be counted as part of the 10-year calculation. And in the skeleton, I've set out the various submissions that underpin that submission. The Secretary of State says, I'm sorry, my Lord,
Sorry, you were just going to do the policy guidance should assist him. And which paragraph do you rely on for that in the policy guidance?
It's the section on breaks in lawful residence. my
Yeah,
lord.
so 160 or whatever, where it was, I think.
Yes. I think I've...
No, and just the page number. You took us to it.
I will find that, my lord, if you just give me a second.
Page 156.
I'm grateful. 156, my lord.
Yeah, thank you.
Sorry, another question for me. Your point about achieving 10 years residence is valid as at the date of the decision. It wouldn't have been valid as at the date of the application.
No.
But it's the date of the decision that counts nonetheless.
My lord, yes, and that is correct. That is also the way in which the policy guidance treats it, and I'll just take my lord to that section. It's page 153 of the authorities bundle. And my lord, if one looks at the last paragraph on that page, you can grant an application if it is considered 20 days, if it is considered 28 days or less before the applicant completes the required qualifying period. So it's the date on which the decision is made that is relevant, rather than the date of application. There are certain provisions in the rules that require a requirement to be met at the date of application, but not 276.
So that was why, yes, that was why I raised the question.
Just while we're on the rules, we were promised in Hague that there was going to be consideration for amending the rules and making them comprehensible for reasonable people.
Nothing, my lord. And my lord will note that in attached to the supplementary skeleton at pages 35 to 38 is the notice of objection in hoc.
This was the Secretary of State's.
Yes, the Secretary of State's notice of objection. I think I quoted from it in the skeleton as well. And the point I was making in the skeleton was that the Secretary of State submitted to the Supreme Court that the Court of Appeal in hoc had clarified a difficult area of law, and this was in relation to whether one counts the period of overstaying as counting towards the 10 years or not. But one can also see that in that notice the Secretary of State did submit that there was no point in the Supreme Court granting permission, because this was going to be reviewed.
Paragraph 10.
Redrafted, yes.
Well, that certainly accords with what I recollect from her,
Yes.
which was that we were promised a way through this maze, and it hasn't yet arrived.
My lord, then, if one then looks at the Secretary of State's current position, which is that this is not bookended overstaying, and the appellant's submission is that is wrong, it is bookended overstaying, for the reasons that I've set out in the supplementary skeleton, and that even if it is not bookended overstaying, it still requires an exercise of discretion, and there has been no exercise of discretion. So if the appellant fails at every stage, we still get, in my submission, to the point where even if that period of overstaying is not bookended, doesn't come within 276b5, the Secretary of State has failed to give any consideration to whether she should depart from the rule and, in accordance with the principles outlined in the policy guidance, exercise discretion. And we say that there are many factors in this particular case that can conceivably lead to the exercise of discretion. And in fact, when one looks at the examples in the policy guidance, one could almost say that this is the sort of case where the Secretary of State has said that she would exercise discretion, albeit in a slightly different context. But there simply hasn't been an exercise of discretion, and the appellant is entitled to a proper, reasoned exercise of discretion that takes into account all relevant matters. And as I've already said, and taking you through at length the decision letter, the decision letter is, in my submission, hopeless in that it just fails to grasp the factual background, fails to grasp the legislative context, and fails to grasp the way in which the rules actually work. It tries to exercise discretion, but does that by reference to the rules, which is not an exercise of discretion. And in my submission, such a decision ought not to stand. It ought to be quashed at the very least, so that the Secretary of State can reconsider this fully and properly and consider whether the appellant ought to benefit from the exercise of discretion, so that he's granted indefinite leave now rather than in November, sometime after the 28th of November 2024. My Lords, unless there is anything further that I can assist you with, those are my submissions.
Thank you very much. Mr. Keith.
My Lords, I noticed the time, but I think I can make a couple of points before we break for lunch. I'd like to deal first with the application of the rules and deal with the purpose of 276B 5 and 39E, although 39E doesn't actually apply to this case because of the dates. That was my error in my first scope argument. I misread the dates of 39E, and when in fact it, of course, being prior to 2016, the 28-day period which the appellant has to get within in order to make the application.
Sorry, can you just repeat that?
So, this case is about 276B 5.
Yeah.
Because 39E doesn't apply, because the period of overstaying is prior to 2016. And my first draft of my skeleton argument, I had misread the dates, and so that's why I amended my skeleton argument. I apologise for that to all parties. But the purpose of the 28-day grace period is outlined in the guidance. The purpose of it is to prevent applicants being penalised for mistakes. So the normal course of events should be, the idea behind a 276B or 10-year lawful residency, that somebody comes to the United Kingdom, for instance on a student visa, stays here for 5 or 6 years on the student visa, extends that visa within time or with 3C leave, perhaps gets a working visa, and then at the end of 10 years, they are entitled to have indefinite leave to remain. The 276B 5 and 39E provisions are designed to bridge gaps where mistakes have been made, because under the normal course of events, an applicant should make an application to extend their leave prior to the expiry of that current leave. And if they do so, they are entitled to 3C leave and are protected as being a resident in the United Kingdom until that application is decided upon. But things go wrong. Applicants miss deadlines, they miss deadlines for very good reasons, or they might make a mistake on the application form, it's rejected, and then they have a gap in lawful residence. Provided that application has been made within the 28-day period and the discretion has been exercised, I'll come back to that after lunch if I may, provided that application can be made within that period, the Secretary of State can disregard that period of overstay. And that is its purpose. Its purpose is not, as my learned friend contends, to allow an individual to make a series of applications until they get a successful one, and then count all of the period of overstaying, either as part of their lawful residence or allow it to be disregarded. And in my submission, the part of the confusion is the term bookended leave that was used in Hock by my Lord Justice Dingemans and Lord Justice Underhill. In that case, it was being considered the applicants in that case were all had open-ended overstaying, so none of them had lawful leave at the time they made the application. And so that phrase bookended leave was used to explain how an individual could have periods disregarded. In my submission, I would phrase the bookended leave not as bookended leave per se, but as leave that can be disregarded within 276b5. And I think Sir Patrick Elias probably puts it better than I do. I think it's 59 of AFSAL. I'll perhaps take to that after lunch as to that definition. Because just because an individual has periods of bookended, just because an individual has one period of leave, a period of overstaying, and then another period of leave, should not, in the Secretary of State's submission, mean that that period can be either discounted or disregarded as per 276b5, or count as the appellant says that it should do. And that's why the table in my skeleton argument, I've tried to explain, mostly for myself, the chronology and where the issues come, in that this appellant made an application within that application window, and if that application had been granted before or on the 29th of October or some other later date, then we wouldn't be here, because there would be a short gap of overstaying under 28 days, a valid application would be made, and the Secretary of State would disregard that period. But the appellant made that application within the 28 days, and it was refused. My learned friend says, well, that doesn't matter, because the appellant can just keep making applications until he gets lucky or gets successful in an application for leave, and then all of that period counts. And my submission is that can't be the case, because there is a period in this application between, I think, 29th of October and 28th of November of 2014, when there is no extant application and there is no leave.
Sorry, period 29th of October.
And I don't want to, let me just check I've got the exact date.
30th of October to 28th November is what you put.
30th of October 2014 to the 28th of November 2014. So at that point, that is pure overstaying, no extant application. And the appellant was of course granted temporary admission on the 28th of November 2014, and that was effectively backdated or became lawful residence that could be counted on the success of his following application in 2015.
Do you say he restarts the clock from the 28th of November 14 then?
Yes.
So the 10 years, so that's your answer to his, if you ignore these bits, I've still got 10 years.
Yes. My submission is that you can't thread together the lawful leave.
Well, it says continuous. Yeah.
You can't disregard that because of that gap. And I'll make one more point. The discretion that my learned friend points to, there are two that he points to in my understanding. The first is a discretion about whether the Secretary of State allows exceptional circumstances for the use of the 28 outside of the 28-day period, and I'll take to the guidance that's involved medical evidence, external events that mean that somebody couldn't put it in with that. The Secretary of State has a discretion to allow a slightly longer period. That's in the rules. And the second discretion that my learned friend, although hasn't expressly said, is a discretion that he has argued in AFSAL and Hock that the Secretary of State has, which is to ignore that even when it doesn't fall within the rules, that the Secretary of State should grant it outside of the rules. And my response to that, again, I'll do that in more detail after lunch, is that this is an application within the rules, and it is a separate consideration period, a separate consideration of an application for leave outside the rules. And that's also dealt with. The point raised in AFSAL about mine and Mr. Giovanetti, Queen's Counsel's concession in Hock, and it's dealt with by Sir Patrick Elias in AFSAL.
So because it said it was within the rules, then it's not whatever anyone might have thought or wanted. You can't then exercise the discretion outside the rules. Is that right?
Yes. It required an application for leave outside the rules is a separate
Yes, certainly. Thank you.